Many things have been said about me. I can say I'm a son, I'm a father, I'm a brother, I'm a friend. Family is always going to be a priority to me. I'm an artist, I'm a coach, I'm a chef, I'm a hunter, I'm a biker, I'm an outdoorsman. This event doesn't define me or who I am. The history of my crime is that I've had parking tickets and speeding tickets. I've never assaulted people or hurt people. I try to see the good in everyone, so starting fights isn't in my nature. I admit that my reaction was too strong, and it's haunted me every day and every night. My drinking was a real problem, and I had fear and broken trust to make a bad situation worse. We were visiting family, making time to help our loved ones when everything fell apart. This event has taken from those people the family and friends who did nothing to deserve the heartache and drama this has thrust upon them. I'm so sorry for my actions, and I wish I made better choices. Life is not perfect, and we weren't either. Moving forward, I will commit to doing my best in her memory.
Thank you, Mr. Ferlazzo.
So if
Is that okay?
Is there more that he wants to say?
yes, this is,
Sure.
Mr. Ferlazzo wrote something specifically to address Mrs. Bass, Adrian.
Adrian, I'm so incredibly sorry for what happened. Emily was my whole world, and she convinced me that I was in jeopardy. I reacted too aggressively, and it's been the worst mistake in the history of my time. Wishing anything else would have played out is a part of every day since. The whole thing was so fast that instantly every possibility and future we planned was gone. I drank to numb myself from the most traumatic event in my life. Little did I know that we'd all be suffering this loss in our own ways. It hurts for everyone who knew Emily and I. We weren't perfect, and our people have the burden of the mess we made. Praying for you and your family to find solace and peace in the wake of this nightmare, to move forward with a healthy path and thrive. Every day it will rain tears, but we can remember the good times and greet the sun again, knowing we felt the love of our Emily.
Ms. Chance.
Thank you, Judge. I just have a few brief comments in response to the state's argument, and the first is to remind the court, which I'm sure the court is well aware of, that this is argument, not evidence. The state has made interpretations and made allegations about Mr. Ferlazzo.
I will say this: I am only going to consider evidence that was introduced in this case, and not things that may very well be true, but are not part of the record.
That was my.
And
that's where I was going.
I'll further say that decisions counsel make to litigate certain issues pre-trial, I'm not going to consider that as a aggravating event either. There is a lot which the state has said that I am going to consider and have been considering, but
Thank you, Judge.
those things I will not.
Thank you. Those were some of the things I was going to raise in response to the state's argument. The state, one thing that I would like to raise, though, is the state has repeatedly referred to his testimony at trial as lying and has endorsed the perjury allegation. He has not been charged with perjury. This court, I'm asking to not consider perjury as.
So how would you have the court consider it if the court finds it entirely incredible, and I don't want to mince words, I do. How would you have the court interpreted?
So over the lunch break, I looked up 13 VSA 2901A, perjury by inconsistent statements. It has 3 prongs. that the person knowingly makes two or more statements under oath or affirmation which are material, that's the statement to the police and the statement at trial. And the statements were made within the period of statute of limitations. The one that I don't think there's evidence before the court is that the statements are inconsistent to the degree that the person necessarily believed one of them to be false. And I don't think there's evidence before the court that Mr. Ferlazzo...
So how do you interpret how he could... I'm fascinated in this question. I wish Dr. Powell would have discussed it. You know, I asked him just a few questions. He didn't think much of the amnesia post-clarity. But how do you interpret that he has a detailed memory of something vastly different, which is much more consistent with all of the evidence, and then over the course of a few years has amnesia for almost every event, except a different version now for what occurred?
So I certainly am not a psychologist. I'm just a lawyer. Neither is the state. And to ascribe his motives in the inconsistent statements to deliberate deception, I don't think anyone in this courtroom can do. He testified that he had been drinking constantly. He testified to that on the stand. And for a chronic alcoholic, my layperson's understanding is that they can be functional if they are, if I may, chronic alcoholics. So the fact that no one else may have noticed that he was constantly, continuously intoxicated over the course of the weekend is not surprising from a layperson's experience having been doing this job. His testimony was a few weeks after the event, he began having dreams about what happened and remembered more clearly than what he said to the police. Now, we have all seen the video, and he appears to be quite rational in the video. That's my explanation, because it's all that's what Mr. Ferlazzo testified to. He began to remember after the fact, after he talked to the police.
So would you agree with the court statement that either he's intentionally lying or he has done whatever he needs to do to psychologically be able to live with himself and has essentially reinvented a story?
So I can't agree with either of those, Judge, because his testimony was not to that effect.
Okay.
I'm not a psychologist.
Right. Good enough.
All I know is what he testified to. He remembered it. Whether that is a function of his having to live with his own actions, I'm not qualified to say. Okay. And I don't think the court is either.
Okay.
His testimony is what it is. But to ascribe it to being a deliberate lie, I don't think there's sufficient evidence before this court, which there has to be a preponderance of evidence in sentencing, and the burden is not on him about any facts that are alleged for the court to take them into consideration for sentencing.
Okay.
And I don't think there's any evidence before the court. There's speculation and assumption about his motivations, about the inconsistent statements. That's all. There's no evidence that he is deliberately lying, and I don't think the court can consider that. And I'm going to refer the court to State v. Blackmer, which is a 2025 case.
You have the site?
I'll give you the citation. 2025 WL 1009533. And in addition to repeating what the court already knows, that it has to be an individualized sentence based on the facts and the defendant's personality, that any uncharged conduct by the defendant must be disclosed sufficiently in advance of sentencing to allow an adequate opportunity for rebuttal. The court may take it into account only if it specifically finds each fact objected to, and we do object to the allegation that he was lying, has been shown to be reliable by a preponderance of the evidence. And it is not his obligation to disprove. So I don't think that the court, and I'm asking the court and would object if the court considers deliberate lying and AKA perjury in fashioning its sentence.
Okay.
So then let me go back. Yes, we asked for a split of 15 years, and I fully recognize that that may be considered wholly and unduly lenient given all the facts of this case. The justification is that voluntary manslaughter was one of the lesser included charges. The jury did not agree, and I respect the jury's decision without question, but I do think that his testimony about passion provocation was consistent both to in his statement to the police and his testimony. And because of that, I think there is some recognition and weight that the court can, not must, but can in its discretion give to his understanding and experience of what happened. So the voluntary manslaughter, as the court and the state know, maximum is 15 years. I think my expectation is that the court will find other factors that negate the request, but that's the basis of that request. And I included conditions of probation should the court decide on a split of whatever length. So that's our basis for the 15 years. As the court knows, and I know the state went through a list of factors, but the traditional factors the court must consider are punishment, specific deterrence, general deterrence, and rehabilitation. Incarceration is punishment. The duration of that incarceration is primarily what's before the court today. I posit that incarceration of any length is extremely difficult, and that people who are incarcerated, their lives are so different from being out in the community, even if they're under conditions of supervision. So the punishment portion of what the court has to consider is the length of incarceration that this deserves. As far as deterrence, general deterrence, the court and the state usually say, send a message to the community that this conduct will not. I am unaware of any statistic or documentation that this is effective in deterring other people from committing crimes. Specific deterrence is quite different. It takes this individual out of society so as not to harm anyone else. And that is a consideration for the court. Rehabilitation is the last of the traditional factors. Mr. Ferlazzo has indicated that he now knows that he has had substance abuse issues for years. He is willing to undergo treatment, both for mental health and for alcohol and drug use. There's no evidence before the court, primarily because of his lack of a criminal record, that he wouldn't comply with that an instruction from the court to undergo and continue for the rest of his life any kind of counseling. This is a man who reached 42 years old with no criminal record. I understand how the state is interpreting the letters of reference, but these are all people who experienced contact with him in a nonviolent and, in fact, supportive and gentle way. The fact of no criminal history is very important, and it indicates that he's able to conform his conduct with the requirements of law. It also indicates that there's no indication that he couldn't comply with future court orders. He developed his profession, and contrary to it being used to, as the state said, lure young women, he was a respected and well-known tattoo artist who earned a reasonable income from that profession. He certainly could go back to that profession if and when he's safely released back into society. There's a lot made of his victim bashing, and he's telling the court and the community what he remembers, his reality. There's nothing else he can do. He cannot, just because he's been convicted, now abandon his claim of self-defense and say, oh, okay, I just made it up. This is what's real for him. That's why he testified to it under oath.
But even if that's true, isn't that one of the things the state's pointing is so scary about the case? If he can create a reality for which things that aren't very real become real in his mind as justification for behavior, isn't that a problem?
No, because the court is assuming that his version is not true, and I'm not disputing the verdict. The jury has made a determination of what they believe is credible, but only he knows what actually happened. And for the court to decide that he's fantasizing or making it up, essentially just so he can live with himself, I don't think there's a basis for that. So to say that, is it a problem that he's essentially reinventing reality, I don't think there's any testimony or evidence that that's the case, other than the fact that the jury didn't.
I'll give you a couple of soft examples.
Sure.
He claimed, and it was all about this image, he claimed they arrived, I think, at 5:30 while it was still light. And he really requested Emily to go out for a walk with him. And it was still light out, and let's do that. And then but she didn't want to. And then again at sunset to do that. I think the uncontroverted evidence is they arrived at, I think, 7:19, well after sunset that night. It's just that, so there's an image he's created for himself one way or another that doesn't seem to be at all connected with what really happened.
Well, I understand the court's example, but frankly, not remembering what time of day.
It was a soft example, but
I hear you, Judge, and I appreciate that the court has that recollection. But that, to me, is such a qualitative difference from remembering the nature of the relationship and what happened that night and the following days that lots of people forget what time they arrived somewhere.
Okay.
And I'm not persuaded that that's a factor that means he's reinventing reality. Okay, so what sets this case apart in my mind are obviously the postmortem from other homicides, or the postmortem injuries, and the court must consider them. I understand how horrific they are, and my condolences to the family and friends. This was horrible, and I know the court has to consider that. My point is that as horrible as though that conduct was, it is one of several factors the court has to consider, not necessarily the controlling one. Albeit, I mean, and admittedly, it's terrible. And I understand the court would have to consider it very seriously. My point is that it's not the only factor. So then, as the court knows, and case law confirms, the court's responsibility is to balance the facts of the case with his character and personality. The state's interpretation of his personality is that he is an egomaniac who lures women into dangerous situations, but that's not what you heard from the people who wrote letters on his behalf. And that is supported by the fact that he had no criminal record up until this tragic event. So in terms of balancing, finding the right balance, the court has a very difficult job. I don't envy the court in trying to find what's just and fair in terms of the facts of this case, the ability for Mr. Ferlazzo to safely rejoin society at some point before he's 80 or 90 years old, under extremely strict supervisions, which would continue for the rest of his life, and the period of incarceration